about that effect? Because I think we really have to drill down on that from a threshold jurisdictional standpoint. I think we have to understand whether race is being used in this context to give rise to an actual concrete particularized injury that would give the members of your organization standing to challenge the use of race in this context. And so I've been struggling to understand exactly, this is sort of where Justice Sotomayor was coming from. I've been struggling to understand how race is actually factoring into the admissions process here and whether there's any actual redressable injury that arises. So can you help us with that, figuring out how exactly does UNC's system work in terms of the use of race? Well, and how your members are being harmed by that.
So let me start with the legal question, which is concrete injury. Gratz establishes that the denial of an opportunity to fairly compete for admission when one of the factors that's used is racial classifications is sufficient to create concrete injury.
Except Gratz was like a set-aside. It was a specific set of circumstances. You could see there that the race factor was creating an unequal playing field because of the way in which the program was structured. Here, I don't really see that happening because no one is, first of all, the university is not requiring anybody to give their race at the beginning. When you give your race, you're not getting any special points. It's being treated just on par with other factors in the system. No one's automatically getting in because race is being used. There's no real work that it's doing separate and apart from the other factors in any different way like it was in Gratz. And when you look at that case, it says specifically when there's a set-aside kind of program, then we have actual injury that gives rise to standing. But I'm not sure you have that here. So can you help me?
Sorry.
Yes, please.
Even Grutter establishes that a holistic admissions process doesn't make the injury go away.
But you've said Grutter needs to be overruled, so we can't, I don't think we can use that decision as the basis for standing.
One of the problems with Grutter that I think illustrates this specifically is Grutter's suggestion that race can only be used as a plus factor and never a minus factor, but as many of the dissenting opinions in that case observed and cases from, or opinions from this court have since observed, that makes no sense in a zero-sum game. If we are going to consider race and we argue that a racial classification, which is highly disfavored at law because of its necessarily invidious nature, is going to be used,
but
wait, then presumably it must be doing some work.
I actually don't think that that's the way standing ordinarily works, and I'm worried that you're asking us for a special standing rule. Well, that you're saying that we can challenge the use of race as a factor without explaining how it's factoring in and how that harms our members. Well, so why is it that race is doing anything different to your members' ability to compete in this environment? They can still get extra points. The points are not being tallied. There's no goal. There's no target. But in any event, they can get points for diversity even in this environment. So why does having race as a factor harm your members in a redressable way?
The record in this case is that UNC gives racial preferences to African Americans, to Hispanic Americans, and to American Indians. It does not give racial preferences to white applicants and to Asian applicants. Moreover—
Are you sure about that? Because I thought that was not a rule, that anyone could get a point for diversity, anyone could get a point for racial diversity to the extent that the other factors in their application allow for it.
No, the UNC, and I think this is in the district court's findings, specifically gives its racial preferences for what it defines as URMs, which are the three groups that I said. And moreover, any effect of race in the process is going to give rise to injury, because the injury that Gratz recognized and that Grutter did not hesitate in at least finding standing in that case and moving on to the merits decision, is that you are being denied the opportunity to compete on a fair playing field, at least a constitutional playing field.
Mr. Shravitz,